Good afternoon, everyone, and thanks for joining us for this webinar, which is one of our regular construction law updates and is a follow-up to our recent webinar on COVID-19, where we dealt with contract and payment issues, BCAR, and health and safety concerns. We have over 500 people attending today from Ireland and overseas, and you're all very welcome to this webinar, which will focus on payment issues in detail and also payment disputes and adjudication. Before we start, I would just like to say that I hope everyone is doing well and getting on as best they can in the current environment, which is very challenging for us all, both personally and professionally. My name is Cillian Dorney, and I'm a partner in Beale & Co.'s Dublin office, where I lead our construction practice. I'm joined today by my colleague Cian O'Gorman, who is a solicitor in our construction group. We, along with our colleagues in Dublin, our UK and Middle East offices, provide contentious and non-contentious advice to the construction, engineering and infrastructure industry in Ireland and internationally. As mentioned, this webinar is a follow-up to our webinar 1st of April, in which we dealt with impacts on construction businesses and professionals of the measures introduced by government on 27th March. We're still operating under those measures, which will continue until at least 5th May, and it's unknown at this point what might occur on 5th May, but we're hopeful that in respect of the construction industry, at least, we may follow the British model with a loosening in restrictions where appropriate. We'll firstly recap on the measures currently in place. Cian will then focus in detail on contractual matters in relation to payments. This will relate to payment issues faced by professional consultants under their own appointments when acting as design consultants under the Public Conditions of Engagement COE1 and private appointments, and also the issues that are arising for employers, agents and contractors under the Public Works contract, as well as the two more common private form contracts, the RAII and FIDIC forms. Cian will also address the matters that should be considered when disputes, in particular payment disputes, arise. And I will then talk in detail about payment disputes with a particular focus on adjudication under the Construction Contracts Act 2013 and how this can sometimes be a good option in order to obtain cash quickly should you have an appropriate payment dispute to refer to adjudication. So firstly, a recap on the measures that were introduced by government to deal with the crisis on 27th March. Those measures were originally put in place until 12th of April, but as we all know, were extended until 5th May. And the main thrust of the measures is that until the 5th of May, everyone is urged to stay in their home where possible. And the reason why, as per the Department of Health statement, is because this is the best way to minimise the risk of COVID-19 to your friends, families and communities. We're told that measures have been extended as they're making a huge difference in the spread of COVID-19, since staying at home means staying in control of the outbreak. There are, however, concessions for those that are involved in essential services, and this applies to some of us operating in the construction sector. From the construction perspective, the government has said that the following types of construction projects are deemed essential. Essential health and related projects relevant to the COVID-19 crisis and supplies necessary for those projects. Repair, construction of critical road and utility infrastructure, and delivery of emergency services to businesses and homes on an emergency call-out basis. The government has also said, in relation to public contracts, that all contractors contracted by government departments or public bodies will be advised as to whether a project is deemed essential or not. This has been the cause of some consternation, particularly for employers, agents and contractors who have recently found themselves in a difficult position where some employers have been unwilling to communicate in respect of suspension of works due to concerns that doing so would give the contractor a right to both time and money on account of the suspension. A certain stalemate developed in these types of situations, which is neither fair to the employer's representative nor the contractor, and doesn't follow the guidance of the Office of Construction Procurement Reform, which is cited utilising the cooperation provisions in the Public Works contract, which is clause 4.1, in order for all parties to appropriately deal with and manage the impact of COVID-19 on projects. From the employer's perspective, in order to get over the stalemate, the Office of Construction Procurement Reform has sought to deal with the matter by operating outside of the contractual provisions and encouraging employers to agree an ex gratia payment with contractors for what are deemed site closure costs. Interestingly, in the template letter / agreement dealing with ex gratia payments, which is available on the website of the Office of Construction Procurement Reform, it's specifically stated that the employer considers that the contract does not provide an entitlement to the contractor to recover costs associated with the delay arising from the closure of the site in the circumstances contemplated by the public health measures. Now, this means that the Office of Construction Procurement Reform's position is that the measures introduced by government are an event 15 in the schedule at Part 1K to the tender and schedule in the Public Works contract, which is a delay event, but is not a compensation event. And this position is confirmed in the advice note of 14th of April, which is available on its website. So event 15 is a delay to the works caused by the order or other act of a court or other public authority exercising authority under law that did not arise as a result of or in connection with an act, omission, or breach of legal requirements of the contractor or the contractor's personnel, or a breach of the contract by the contractor. Essentially, in agreeing ex gratia payments, the government is trying to avoid a situation where the shutdown of public sites qualifies as an event 3 under Part 1K to the tender and schedule, which is the employer's representative directing the contractor to suspend the work, because that act qualifies as both a delay and a compensation event, thus entitling the contractor to both time and money. So the government is most certainly trying to get a better deal by negotiating an ex gratia payment mechanism over what might occur should the contractor obtain a right to be compensated under the contract via event 3 on account of the closure of sites. Now, that stance will undoubtedly give rise to additional claims, particularly if contractors don't feel that they're getting a good enough deal through the ex gratia payment facility. And it will be interesting to see where that topic actually goes in the industry. Taking just a step back for a moment to give a context of the legal position with regard to where we sit right now, as well as the position with regard to further measures that may occur, it's just useful to understand the legislative framework that we're now operating under. There's 2 pieces of legislation that have been introduced to deal with COVID-19. These are the Health Act 2020 and the Emergency Measures in the Public Interest Act 2020. The first piece of legislation provides the government with powers to make regulations with regard to movement that we're all subject to now. It confers on the Minister for Health the power to make the regulations prohibiting or restricting the holding of certain events or access to premises, and to provide for enforcement measures. And it also provides additional items such as the extension of social welfare payments. The second piece of legislation is the Emergency Measures in the Public Interest Act, and that facilitates making provisions in relation to the rental sector and provisions in relation to the Planning and Development Acts. These extend the period of public participation in the planning process, and this is an obvious matter for construction professionals, as delays undoubtedly going to arise with projects that are currently in the planning phase of development. So I'll now hand over to my colleague Cian, who will discuss how the measures implemented under this legislation have affected and are continuing to affect matters to do with payments in professional appointments and construction contracts. So Cian, over to you.
Thanks, Killian. Hello everyone, and thanks again for joining our webinar today. As outlined by Killian, I'll begin by examining the key payment issues to be aware of when operating as a consultant in both the public and private sector. In particular, I will address the Public Works Standard Conditions of Engagement, and I will also discuss the payment matters that arise in private form appointments. I will also consider payment issues that arise under the Public Works contract, the RAII standard form, and the FIDIC forms of contract. The analysis of these contracts will be equally relevant to employers, employers' representatives, and contractors. Lastly, I will consider what happens if an issue to do with payment turns into a dispute, which then needs to be progressed with under the various forms of contract. The importance of familiarizing yourself with your contract in such volatile and uncertain times cannot be emphasized enough. It is the contract that sets out all the obligations you owe to your client, and indeed that your client owes to you. Sometimes, as I'm sure you can all attest to, strict adherence to non-statutorily imposed contractual obligations related to payment and other matters can become relaxed as a project is ongoing, right up until and beyond completion. However, in situations such as the current crisis, where certainty of payment is in question and disputes are threatened and arise, we see parties who may have been previously lax in adherence to the contract suddenly seeking to enforce and rely on it heavily. This may occur, for example, in relation to compliance with conditions precedent. For this reason, it is more important now than ever to have a good knowledge of the clauses in your contract related to payment. I will first look at the position in this regard from the perspective of consultants operating under the Standard Conditions of Engagement on Public Contracts, COE1. As Killian already outlined, it is clear from the measures introduced by government that it is for public body employers to determine whether a project is deemed essential or not. So at this stage, if you have not already heard, which would be surprising, you should query the position with your client. If the project is essential, then works will continue in line with the Department of Health guidelines on social distancing, etc. If the project is non-essential, then it will depend on the stage that the works are at as to whether or not work continues. The Office of Construction Procurement Reform issued useful guidelines on 14 April in relation to what should occur under the Standard Conditions of Engagement, both where projects are essential and also where they are not. The link to where this guidance is can be found on this slide. With regards to projects that are non-essential, where they are at early stage, i.e. project design or production of tender documentation, the guidance is that work can continue up to the next design team service stage unless the client invites a suspension under clause 411 of the contract. Overall, the guidance provides good direction on how employers and consultants should conduct themselves in the current crisis with regard to the provision of services and payment. It states as follows: both parties shall establish the best approach to ensuring the service can be continued if necessary within redefined delivery parameters. The client may consult with the consultant for the purposes of considering whether reducing the periods between payments through the introduction of sub-milestones or intermediate delivery requirements would be beneficial. This applies regardless of whether the project being worked on is deemed essential or non-essential. We would suggest to both employers and consultants that it would be sensible to adhere to this guidance in the current environment in order to ensure least impact on services and payments possible. This should also help cultivate the right environment and to avoid claims, which will assist in work being progressed most efficiently once the restrictions are loosened in the future. I will now go through the contractual provisions that apply to payment issues on projects in the construction stage that have been affected by the current measures. Such provisions deal with delay and suspension. Beginning with delay, as dealt with in Clause 4 of the Standard Conditions of Engagement on Public Contracts for Consultancy Services, Form COE1, which sets out the obligation with regard to providing the services in line with the programme. It states as follows: 1. The consultant shall start its services for a stage when the client gives permission. 2. Perform them regularly. 3. Meet each milestone within the stage. 4. And complete the services for the stage within the performance period scheduled for it. Obviously, the consultant's ability to meet the milestones and complete the stage within the schedule is made impossible under the current circumstances. We must therefore look at Clause 5, which deals with relief for prolongation or the costs you incur as a result of a delay. It notes that the consultant is entitled to compensation unless the delay to the completion of a stage is due to the consultant's breach or a special circumstance. Delay of the project is included within the definition of a special circumstance. The result is that due to the definition of special circumstance, which critically includes delay to the project construction contract, is that the client may seek to withhold costs incurred by consultants in the period of the delay. Suspension is also dealt with under Clause 4 of the Standard Conditions of Engagement. Clause 4 states that the client may, by notice, suspend the consultant's performance of all or any services. This is obviously, again, of direct relevance here, with clients having opted to suspend contracts in the circumstances. With regard to payments during the period of suspension, the position is that the client will be required to pay the percentage of stage fee for suspension included in Schedule B. Consultants should check Schedule B for what this percentage is, which is to function as payment for all effects of the suspension on the consultant's costs. Half the addition is due with the notice and the rest when the suspension ends. The client shall also pay any direct costs at the scheduled time charges for emergency requested services. A question, therefore, which arises here is whether the client will actually choose to suspend the provision of services or not. Considering that it can be liable for some payment on suspension, it may choose not to suspend, but instead to continue with the provision of services, albeit perhaps at a reduced level until the project restarts. Notwithstanding the contractual position as outlined in the previous slides, which you should be cognizant of at all times in order that you're aware of your position under the contract and indeed your exposure. Given the guidance mentioned earlier as issued by the Office of Construction Procurement Reform, we suggest that consultants and clients engage pursuant to the cooperation provisions at Clause 8 of the Standard Conditions of Engagement. Pursuant to Clause 8, this encompasses the following. 1. Continue with the provision of any services that can be provided even when works are stopped. 2. Agree the manner in which the provision of services may have to be altered given the stoppage of the works. And 3. Restructure payment provisions as appropriate. Additional guidance issued by the Office of Construction Procurement states the following. Even though a consultant cannot attend site to oversee construction operations, there may be a range of ongoing duties and tasks to be undertaken. The duration of the restrictions associated with the public health measures remains uncertain. It is recommended that clients call a meeting under Clause 8 of COE1 where both parties to the services contract may engage on a without prejudice basis to establish the necessary and appropriate arrangements for the duration that the public health measures continue to adversely affect the delivery process that would otherwise have occurred, together with the consequences for the service provision and the project. Turning to the position in relation to payments under private sector contracts. As mentioned, there are a great many number of private form professional appointments in use in the industry currently, which can range from simple proposal letters that incorporate standard industry body terms and conditions to fully bespoke letters of appointment. Notwithstanding the form that consultants are operating under, the issues with regard to payments remain the same, and the extent to which they apply will only be evident on a detailed reading of the contract. The relevant issues can be categorized generally as follows. 1. Establishing and maintaining an entitlement to payment. For example, are there any condition precedents to payment within the contract that apply? If so, you should ensure that these have been complied with. If they have not, this provides an easy method by which the client can withhold payment. 2. Payments may be tied to the completion of various milestones. With the current measures in place, these milestones may now be impossible to achieve. Is there a mechanism that provides for altering these? For example, is there a cooperation clause that may be invoked whereby sub-milestones could be included to ensure that payments, even reduced payments, continue to be made? 3. What are the consequences of suspension? Will payments, again, even reduced payments, be made? Will you have the right to terminate the contract after a certain period of suspension? You should bear this in mind if the contract is one which is perhaps not the most profitable or is loss-making. 4. If the client decides to terminate, what are the consequences? Usually, you will be paid the proportion of the fee commensurate to the services that you have been provided. 5. Lastly, what if a dispute as to payment has arisen? What are your options? Killian will address this later in the context of adjudication, but there is, of course, a concern, especially on private projects, that funding may start to become a problem and parties that are owed money may have to commence a dispute resolution process in order to obtain the funds that they are due. It may be necessary to commence an amicable settlement process or indeed a formal process to compel a party to pay the sums you are due, using, for example, adjudication. It is clear from the discussion in relation to both public and private sector contracts that the prudent consultant right now should, 1, be aware of all the contractual provisions that apply such that its risks be identified and managed, and secondly, notwithstanding what the strict provisions of the contract are, look to engage with the client in order to agree a practical manner in which to proceed to reduce payments to the services to be provided by the consultant, the corresponding payments, and the project overall. I will now focus on the RAII and FIDIC forms, and my comments will be equally applicable to employers, employers' agents, and contractors. Starting first with the RAII form, and I am referring to the RAII Standard Blue Form 2017 edition. The first clause to take note of, which deals with costs, is clause 4. This relates to variations arising from legislative enactment and states as follows: where the cost of performance of this contract is increased or decreased as the result of any legislative enactment, rule, or order of the exercise of government powers vested in it, the amount of such increase or decrease as certified by the architect shall be added to or deducted from the contract sum. While this clause was not strictly drafted for the intention of encompassing an event such as the current circumstances, it is clearly wide enough to encompass the legislation enacted by the government to deal with the current crisis. Consequently, contractors could well be entitled to their additional sum costs of completing the contract due to the measures implemented. However, it must be noted that this clause is usually sought to be removed by employers, and if it does remain, it is generally amended to an extent. So it is worth checking any amendments to the contract to see whether, and indeed to what extent, this clause has been amended. The second clause to take note of, which deals with time, is clause 30, entitled Delay and Extension of Time. This is of direct relevance here and states as follows. If, in the opinion of the architect, the works be delayed by A, force majeure, B, by reason of civil commotion, J, by any act or default of the employer causing delay in the progress of the works as provided for in clause 29b, then in any such case the architect shall, as soon as it is possible for the architect to do so, make a fair and reasonable extension of time for completion of the works. The occurrence of COVID-19 could well qualify as a force majeure event entitling the contractor to additional time. However, again, any amendments to the standard form should be checked to see whether the definition of force majeure has been restricted in such a manner that would result in COVID-19 being excluded as a relevant event. If it has, there may be an alternative by which extensions of time could be sought. For example, could COVID-19 be considered civil commotion? This is perhaps too much of a stretch in the current environment, but it may become applicable depending on how matters evolve. Lastly, has any act or default of the employer in the current crisis resulted in delay? If so, there will be an entitlement to an extension of time. What is critical is that as the standard form contract is generally heavily amended, the full schedule of amendments should be reviewed to identify what precisely the position is with regard to entitlements under the contract, as well as what needs to be done to obtain or maintain those entitlements. For example, giving notices at the appropriate time. Also, new clauses are regularly added that substantially amend this form of contract, turning it from relatively contractor friendly to sometimes entirely the opposite, as well as every shade in between. FIDIC 1999 and 2017 Rainbow Suite, both versions contain very detailed force majeure provisions. If we look at clause 19 of the 1999 Red Book, for example, whilst it does not list disease or epidemic as a force majeure event, it defines a force majeure event as one which is beyond the party's control, 2, which such party could not reasonably have provided against before entering into the contract, 3, which a party could not have reasonably avoided or overcome, and 4, which is not substantially attributable to the other party. As such, we think that contractors will be able to claim COVID-19 as a force majeure event and will be entitled to an extension of time for any delay by reason of COVID-19, although not to payment of additional cost. The FIDIC forms contain very prescriptive wording in relation to contractors' claims. For example, clause 20.1 of the 1999 Red Book provides that if the contractor considers itself to be entitled to any extension to the time for completion and/or any additional payment as a result, the contractor shall give notice to the engineer describing the event or circumstance giving rise to the claim. However, note that FIDIC imposes a time limitation of 28 days during which notices need to be brought from the date on which the contractor became aware or should have become aware of the event or circumstance causing delay. Crucially, the consequences of failing to give notice when you should will be serious, as Clause 21 provides that failure to comply with this time period will mean that the contractor shall neither be entitled to an extension to the time for completion, nor shall it be entitled to additional payment, and the employer shall be discharged from all liability in connection with the claim. There are also additional requirements to be followed once a claim has been made. Employers and employers' representatives in particular should be cognizant of such matters and ensure that the contract is operated as it should be to ensure no obligations regard to notice have been waived. As Killian mentioned at the beginning of the webinar, we've seen in the market employers disengaging and employers' representatives being left to do what they think is necessary, particularly in respect of contractor entitlements as a result of suspensions. This obviously puts employers' representatives in a difficult position, since the employer could seek to recover from them in circumstances where the employer suffers loss due to their decision. As we have seen from the mechanics of the above contractual suspension, delay, and payment clauses, in the event the employer or employer's representative suspends the contract, this will trigger entitlements to extension of time as well as additional cost. In the event that the ER does not give a formal suspension notification, this will leave other parties uncertain about entitlements to payment pursuant to the suspension clause and will likely result in contractor claims. Consequently, it is to the benefit of all parties that the relevant ER notices are issued. That said, the ER should not necessarily be forced into giving the suspension order, and in order to protect itself, should seek formal written confirmation from the employer as to their position with regard to the suspension. As set out above, if possible, all parties should seek to cooperate as much as possible in order to identify the manner in which matters should be progressed in the best interest of the project, with protecting public health as the guiding principle. Moving on to dispute resolution clauses in your contracts. In the event that continued efforts to cooperate and negotiate do not bear any fruit and payment is not forthcoming, then engaging in dispute resolution may be the next viable step. Each of the standard forms, both public and private sector, have their own dispute resolution clauses, which I will examine now. At the outset, we would always advise that it is worthwhile attempting to amicably resolve a dispute at an early stage, or indeed at any appropriate stage, through commercial meetings and without prejudice negotiation, ensuring that all attempts to do so are conducted strictly on a without prejudice basis. The threat of a formal referral to a dispute resolution forum, particularly at the outset of a matter, can often also assist in focusing parties' minds and sometimes leads to early settlement. The dispute resolution clause in Form COE1 is set out in Clause 16. It states that, subject to any conciliation, adjudication under the Construction Contracts Act 2013 or other initial method agreed by the parties in the schedule or after contract for resolving a dispute or issue in a dispute, all disputes between the parties in connection with the contract services shall be finally decided by arbitration. Form PWCF1 deals with this in a slightly differing manner. The dispute resolution clause there is set out in Clause 13. 13.1 sets out a dispute management procedure which must be referred to if a dispute arises under Clause 10.5. Clause 10.5 deals with any determination made by the ER on foot of either a claim by the contractor for an extension of time or adjustment to the contract sum, or a proposed instruction by the ER. Clause 13.2 then deems that either of the parties may refer a dispute to conciliation. Clause 13.3 provides that either of the parties may refer the matter to adjudication. On the basis of statute, a payment dispute can be referred at any time. Should a dispute that has been referred to conciliation be referred to adjudication, the conciliation immediately adjourns. This is to avoid an abortive conciliation process, and particularly to avoid the potential costs for a conciliator's recommendation that conflicts with adjudicator's decision. Clause 13.4 states that any dispute shall be finally settled by arbitration in accordance with the arbitration rules identified in the schedule. Turning to the RAII standard form. Clause 38A states that should any dispute arise which is not resolved by negotiation, the parties shall enter into conciliation. Pursuant to Clause 38A2, either party may commence conciliation by sending a written request for conciliation to the other party. Conciliation is a mandatory step before proceeding to arbitration. Arbitration is dealt with in Clause 38B, and similar to conciliation, the process is commenced by sending a written notice to the other party. Similar to my comments with regard to payment issues that arise under this form of contract, the amendments to the contract should be checked to identify whether the dispute resolution procedure has been altered. It should also be borne in mind that even though an amicable settlement process, such as two directors meeting within a certain period in an effort to resolve matters, is not precluded in the provisions of the contract, this does not prohibit the parties from attempting to resolve the matters in that way. Also, statutory adjudication is available to parties at any time, notwithstanding the prescribed procedure. For the purpose of this slide, I will refer to FIDIC 2017 suite of contracts. Under the 2017 suite, Clause 20 addresses claims and Clause 21 addresses disputes. This change emphasizes the FIDIC distinction between claims and disputes, i.e., a claim is an assertion of an entitlement on the terms of the contract, and a dispute arises when a claim is rejected. Clause 20 of the suite of contracts deals with contractor claims and employer claims together, and the same rules apply to both. Clause 8.4 provides that each party and the engineer, where applicable, shall advise the other in advance of any known or probable events or circumstances which may adversely affect the works. Clause 1.3 requires notices, including notices of claim, to be identified as a notice and refer to the provision of the contract under which it is issued, which aims at limiting the scope for disputes relating to the validity of a purported notice. One of FIDIC's golden principles, which enshrines FIDIC's core contracting philosophy, provides that all formal disputes must be referred to a dispute adjudication board for a provisionally binding decision as a condition precedent to arbitration. Again, notwithstanding the content of this contract with regard to disputes, statutory adjudication pursuant to the Construction Contracts Act 2013 is still available for the parties to refer payment disputes at any time. Killian will now discuss adjudication in detail. Over to you, Killian.
Thanks, Cian, for a very in-depth look at payment disputes and disputes clauses. One of the most, I will now give a brief overview of the adjudication process under the Construction Contracts Act 2013. So one of the most significant issues affected by the COVID-19 crisis is cash flow. And cash flow is the lifeblood of every industry, but it's critical in construction. With payments being delayed, deferred, or not being made, parties within the contractual chain on construction projects are certainly looking for other avenues through which cash can be obtained. And one area that they're looking at is claims. In recent years, on account of the level of activity in the market, claims have somewhat been left to gather dust since it's been more profitable to get on with new work and new projects. But with increasingly little or with no work to do, that position's changed, and progressing with valid claims is now seen as a viable option or a viable method by which cash-strapped businesses can obtain funds to try and stay operating. Excuse me. In some cases, progressing with the claim is actually seen as the last roll of the dice for businesses that do need cash. As Cian's outlined, dispute resolution clauses come in many forms, and in construction contracts, a stepped dispute resolution procedure is generally included. The initial step might involve two directors meeting within a certain period of time in order to attempt to resolve the dispute amicably. Excuse me. And this may then be followed either by mediation or more usually conciliation, with the final step being either arbitration or litigation. Adjudication, which is the dispute resolution procedure prescribed by statute, which is the Construction Contracts Act 2013, is a process that's available only to parties to a construction contract, but which definition includes professional appointments. And it's a process that is available in addition to and notwithstanding what a party's contract says. So even if a contract says that the Act doesn't apply, that term will be ineffective. You cannot contract out of the Act. And adjudication is also available at any time. And it's envisaged that a decision will be provided within 28 days from the date that the referring party delivers its initial submission, which is its referral notice. And the decision that is delivered is binding unless and until a different decision is reached in arbitration or litigation. And the sums awarded in adjudication are generally payable within 7 days of the decision. So adjudication is then potentially an extremely useful method by which you can compel a party to engage with you and obtain money you are properly due quickly, assuming your claim is successful. That said, there are some critical questions to ask yourself before commencing adjudication. The primary matter to consider before progressing with the claim is whether you have a valid entitlement. And in basic terms, the question is whether I have a good claim or not. And it's worth identifying this early on before any significant cost has been incurred, because what you don't want is at the 11th hour to realize that your claim isn't as good as you thought it was. So early specialist advice will help you both identify your entitlements and also develop the right strategy to maximize your entitlements. And it will also help you to identify the weaknesses in your own position. And that's invaluable, particularly in the context of knowing what a good deal is if you are able to compromise the dispute in a without prejudice negotiation before a formal dispute resolution process has either started or concluded. You'll also need to be sure that a dispute has actually arisen and that it is a payment dispute. Clarifying those matters early will help you avoid any jurisdictional challenges that your counterparty may make. And even though adjudication is really an excellent procedure, it should be borne in mind that it won't be suitable for every payment dispute. For example, where both parties are in agreement that there is an entitlement, but the dispute relates only to the amount to be paid, mediation might suit best, especially if the parties aren't that far apart and if they want to maintain their commercial relationship into the future. That said, in the current environment, what seems to be occurring more regularly is that one party is suffering significant cash flow issues, with the other party disputing any entitlement to payment at all. And for these situations where obtaining payment in short order is critical and where the dispute is limited to payment issues, adjudication is certainly appropriate. As Cian mentioned, in our experience, it is always worthwhile attempting to amicably resolve a dispute at an early stage, or indeed at any appropriate stage, through commercial without prejudice negotiations, and the threat of adjudication in such discussions, particularly at the outset of the matter, can assist in focusing minds and regularly lead to settlement. But even if settlement doesn't occur, the commercial negotiation process will give you a feel for how your counterparty might approach the dispute once you have commenced adjudication. One matter to be aware of in commercial negotiations is that information you choose to disclose and the basis upon which it is disclosed. If you're making any concessions at all discussions should be had on a confidential without prejudice basis, so that anything you say remains confidential and cannot later be used against you in the formal adjudication process. Assuming that early without prejudice negotiations have failed, and on the basis that adjudication is the most appropriate formal process to proceed with, the first step is to commence the process by delivering on the counterparty a relatively simple document called a Notice of Intention to Refer Payment Dispute to Adjudication, or more simply, the Notice to Refer. The Notice to Refer identifies in simple terms what your payment claim is. Although it's a short document, it is a very important document as it sets the scope of the dispute and so the adjudicator's jurisdiction. Essentially, it tells the other party what the dispute is and tells the adjudicator what it is he or she has to decide upon. After delivering the notice to refer, you'll need to have an adjudicator appointed. This is done either by agreement or, in the absence of agreement, by applying to the Construction Contracts Adjudication Service, where the chairman of the statutory panel of adjudicators will then appoint an appropriate adjudicator for you. After that, you will need to deliver your referral notice. And as I mentioned already, the delivery of the referral notice commences the 28-day period under the Act within which the adjudicator's decision is to be delivered. So this period is taken up with the parties providing further submissions and, if necessary, the adjudicator meeting the parties or visiting the site if the adjudicator deems that to be appropriate. That said, in the vast majority of cases, adjudications are conducted on a documents-only basis, and that helps to keep costs down. Once a decision is delivered, then the sums identified as due will usually be directed to be paid within 7 days of the decision, and the adjudicator will also direct how his costs are to be paid. Generally, like litigation, costs follow the event, so the successful party will be directed, or the unsuccessful party will be directed to pay the majority of the adjudicator's costs. However, the other costs of the parties cannot be awarded, and they are borne by each of the parties themselves. Even though adjudication provides only an interim binding decision, meaning that a party can proceed to arbitration or litigation to try and achieve a better result, from a time and cost point of view, adjudication does get you to a position where money is released quicker than any other available formal dispute resolution process. And for that reason, it is extremely attractive. The contrast is stark when compared with the traditional construction disputes route of conciliation followed by arbitration. It's the difference between obtaining money in a matter of weeks, about 8 weeks or so in total from the date you issue your notice to refer to the date money should be paid, and a matter of years, up to 2 years or more in the context of conciliation followed by arbitration. The same is true from a cost perspective, and depending on the complexity of the dispute, an adjudication can be run very efficiently. But even when disputes are complex, the difference in costs in adjudication versus conciliation arbitration is still a significant difference, and a difference of between a few tens of thousands, if even, and a few hundreds of thousands in the arbitration field. Consequently, for the construction professional, contractor or subcontractor, adjudication is an attractive method by which to unlock funds quickly and cheaply when compared to other formal dispute resolution methods. And that may allow you to obtain the cash your business needs in order to maintain itself and its people through the current COVID-19 crisis and beyond. So that brings us to the end of this webinar. We hope you found it useful. We'd be, of course, very pleased to discuss in depth anything Cian and I have mentioned today, and or to discuss further any particular issues or concerns that you might have in relation to specific projects. Apologies, we've run on slightly, but I hope we have been able to answer most of your questions in this webinar. But any questions we haven't covered, we'll attempt to answer via email over the course of the next couple of days. As I touched on at the beginning, this webinar is part of a series of webinars that we at Beale & Co have been hosting and will continue to host in relation to COVID-19. So please see our website for upcoming webinars and also articles. If you do need support on COVID-19 or other project-specific issues, you may be interested in Beale & Co.'s in-house lawyer service. This is a virtual service and provides you with access to any member of the contracts and projects advisory team as if you had an in-house counsel helping you on your projects. The advice we give is commercial, it's frank and direct, and it's quick. And the rate card involves a significantly discounted hourly rate compared to our standard hourly rates, with a lot of flexibility over the period of the retainer. So the details are on the slide, and we'd be very happy to discuss that with you if you are interested. It remains to say thank you for joining me and Cian this afternoon, and I hope everybody stays safe. Thank you and goodbye.